Welcome to this talk on the crypto asset reporting framework, new challenges for crypto businesses. Now, crypto businesses are probably all fairly new anyway, so they're already facing a lot of new challenges. If we could just go to the first slide, please. But this is a new challenge. Now, this arises out of the now long-standing changes brought about primarily by the OECD inclusive framework to how revenue authorities exchange information with each other. And we have the CRS, the Common Reporting Standard, and in more recent years, there's been some concerns that CRS would not apply to crypto asset platforms and crypto type businesses. And so the OECD has come up with the crypto asset reporting framework. Now, there's good news and there's bad news. And I think it's all good news, really. So the good news is that we have we now have an implementation framework. So a couple of years ago when we were talking about this, we thought it would probably be in place now. It's not. And in fact, 48 countries, including the UK, have agreed to implement by 2027. So that will be that will include the sharing requirements by 2027. So if you remember, there'll be if anyone remembers from CRS, there'll be the process of beginning to do collection of information, etc., and getting that into domestic revenue authorities before the revenue authorities themselves will do the actual exchange. But 48 countries have agreed to implement that. And I'm on Rebecca's slide. Sorry, Rebecca.
No, that's fine.
What the statement said.
Yeah. So the statement says, as Harriet's just alluded to keep pace with the rapid developments and growth of the crypto asset market, and to ensure that recent gains in global tax transparency will not be gradually eroded, we welcome the new international standard on automatic exchange of information between tax authorities developed by the OECD, the Crypto Asset Reporting Framework, or CARF. The widespread, consistent and timely implementation of the CARF will further improve our ability to ensure tax compliance and clamp down on tax evasion, which reduces public revenues and increases the burden on those who pay their taxes. And the surprising or unusual thing about this is that the US is involved, because they're not normally, are they, Harriet?
No. So the US initially said they weren't going to get involved with CARF. And Rebecca and I have had a long discussion this morning about whether we should say Crypto Asset Reporting Framework or CARF. And I have decided I'm always saying CARF because I'm lazy. And the US are actually one of the 48 signatories to this statement on implementation. So it's a bit of a turnaround on CARF itself, because back in 2022, the US were not particularly interested. But also, it's an unusual step because the USA generally don't sort of get heavily involved in international tax measures. They tend to go their own way, as we can see with guilty instead of BEPS. They have their own model double tax convention, and they have FATCA instead of CRS. So I think it's really interesting to see where this leads in terms of the US coming in on those sort of international projects I mean, they're always involved, they're part of the OECD, they're part of the inclusive framework, but they don't always adopt what comes out of it, if that makes sense. So Rebecca, I think you're now going to tell us on the next slide about what we're going to talk about today.
Yes, so what we're going to cover is as follows. So we're going to do an introduction to the CARF, which we've already sort of looked at. Yeah. How CARF interacts with CRS, changes to the CRS. We're then going to look at defining crypto asset service providers and reporting crypto asset service providers. Then we're going to look at what triggers a report and what has to be reported, the interaction with MDR, and then some practical steps to take now. So moving then to the next slide, Harriet's going to continue introducing this topic.
So we've talked about this a bit, and so the OECD produced a paper in July of last year where they set out some model rules again, and what they say is that the aim is to extend CRS-style reporting to crypto asset service providers, CASPs. And I have a query which I've had all along. was it really necessary? Because in my view, an awful lot of CASPs would in any event be financial institutions required to report under CRS. Now, those of you who work in or with crypto businesses may be aware that initially there was a view among those working in the crypto industry, crypto bros, if you like, that that crypto somehow was magically not taxable, and crypto wasn't sort of something that revenue authorities could or would be interested in. Now, hopefully that view has now been largely overcome, and people understand that crypto assets are assets, and if they have a value, if you get rid of them and you make a gain, they're just like any other asset. They're an intangible, they're an unusual intangible, but that's all they are. So I think part of the reason why, instead of just saying, well, look, of course, these crypto businesses are financial institutions within the CRS, it's been simpler to simply say, well, let's not worry about whether or not that's the case. We'll just have another set of rules for crypto asset service providers. Now, is that necessary? We'll discuss that a bit more towards the end. So as with CRS, CASPs are going to be required to perform due diligence on all their customers. And you're going to have two types of customers within the regime: individual customers and entity customers. Entities are basically everything that isn't an individual, so a trust, a foundation, a company, a cell of a company. If you have cell companies, all of those things are going to be entities. And once the required due diligence has performed, CASPs will then need to report information to their local tax authority, again, very much like CRS. And the local tax authorities will notify the tax authority of the customers of the information reported. So there'll be exchange of information, again, very much like CRS. However, important to remember, there is a separate MCAA, or there's going to be a separate MCAA for CARF. So it will be necessary to activate exchange relationships, and the exchange relationships that are active may not be the same as for CRS. We've got approximately 140 country participants. As we know, we've got 48 signed up for implementation by 2027. Those include all of the key participants listed there. They're all going to implement by 2027, as is the US. And the OECD say boldly that CARF is designed to end the culture of secrecy and opaque transactions. I hope that's right. And we've just put on the slides, which you'll be able to access after the talk, we've just put a link to the US statement about the joint statement. So yeah, I think that's I've put that there because I couldn't quite believe it. So if you don't believe it either, you can see it. The US Treasury says so. So on the next slide, we're looking at CARF and CRS and how they interact. Now, as I've said, CARF consists of a short, compared to CRS, a really short set of model rules and some commentary. This covers the scope of crypto assets that are within scope, and crypto assets is, as you would anticipate, defined fairly broadly. I suspect when we have finalized commentary, that's going to really major on how broad the definition is. It covers the entities and individuals subject to data collection and reporting requirements, the transactions that are subject to reporting, as well as the information to be reported, and the due diligence procedures to identify crypto asset users and to determine the relevant tax jurisdictions for reporting and exchange purposes. Now, to pause there, for those of us who've been dealing with CRS for some time, these processes are very similar to CRS. The due diligence is similar to CRS. Even the due diligence for existing customers before this comes in has a commonality with what we did back in the day for CRS for our existing customers. So if you've dealt with CRS before, this is going to be relatively familiar. The problem is where we have institutions, CASPs that aren't used to dealing with these sort of regimes, and that's why we think it's really important to start preparing your clients for these changes now, because it may require institutional change, it's going to require policy change, and possibly it may even require convincing some clients that they're within scope. So it's really important that we don't all sort of wait until 2027 and then go, oh, we should have done something about this. and that's why we think it is important. So in addition, we've got a separate multilateral competent authority agreement for CARF. We don't yet have the XML schema to support automatic exchange, but that is coming. I imagine it's going to be pretty much the same as CRS. So what I'd say is the regime is basically a CRS regime which takes into account technological developments and dissemination since the design of the CRS way back when. And so it's not something to worry about. It may be something that your clients find worrying, particularly if they come from the technology side of the crypto business rather than the financial side of it. So it's going to be a matter of hand-holding some clients through the process of getting on with this. Now, I'm now going to just talk briefly about the CRS amendments, because the CARF paper from July also contains some amendments to CRS, and it's very much the same thing. Digital technology has moved on, and so the rules need to move on as well. And so the amendments to CRS are all sort of, or mainly focused on digital financial products. So new digital financial products are included in scope because they constitute a credible alternative to holding money or financial assets in an account that is currently subject to CRS reporting. Of course, if they weren't in scope, or when they weren't in scope, then if a person was transferring an asset within scope of CRS into those digital financial products, you'd probably have had to make an MDR report. MDR is the mandatory disclosure rules, because you've got somebody where they may be seeking to avoid or actually avoiding the application of CRS. So this is in some ways good, because it takes away that question of, do you have to do the much more onerous MDR reporting? Within CRS are now covered specified electronic money products, or what I'm going to call SEMPs, and central bank digital currencies. To manage concerns in relation to CARF, there are changes made to the definitions of financial asset and investment entity, and these are designed to ensure that derivatives that reference crypto and are held in custodial accounts and investment entities investing in crypto assets are covered by the CRS. So we have CARF, we have CRS. If they weren't covered, we're trying to make sure they are covered, but we've got CARF as well. So what the OECD says about these amendments is they are to ensure an efficient interaction between CRS and CARF, and in particular to limit instances of duplicative reporting while maintaining a maximum amount of operating flexibility of reporting financial institutions that are also subject to obligations under the CARF. So what we're going to come on to further on is that if you are a reporting FI under CRS, but you also have a CARF obligation, you're going to be able to rely on a lot of what you do in CRS rather than doing the whole thing again for CARF. Now, on the next page, the OECD says that this is designed to enhance the reporting outcomes under the CRS through the introduction of more detailed reporting requirements and the strengthening of due diligence procedures. In addition, and I think this is a really good addition, they've got a new, and they call it optional, non-reporting financial institution category for investment entities that are genuine non-profit organisations. Now, again, for those who are ancient like me, you may remember we had FATCA come in most places in one year, and then CRS in the subsequent year. And FATCA sort of had this carve out for basically for charitable organisations, and CRS didn't. And this amendment is going to bring CRS much more into line with FATCA. Now, it doesn't need to be in line with FATCA. There's no reason why it should be. However, I think not reporting on charities is probably the right way to go. We get a new excluded account category for capital contributions account, and we've got an addendum to the CRS multiple competent authority agreement, which is giving an updated legal basis for participating jurisdictions exchanging CRS information. So while we've got a big chunk there, which is to do with digital assets, the OECD has also taken the opportunity to give some tweaks, which hopefully is going to make CRS work more efficiently and more effectively. So those are the CRS amendments. It is, if we could just go back to the previous slide, it is worth just looking at what SEMPs are if you have a moment. It's quite interesting. And if you work a lot with digital economy businesses, then you're going to want to know what's going on there. We're not going to go into this now because, as I say, this is primarily about CARF, but just bear that in mind. Now, if we could now go to yes, thank you very much, Brahmi. No, the next one, you were right. That's right, perfect, thank you. Rebecca, I think, is going to take us through the institutions that are in scope.
Yes. Yes, so starting then with what we're looking at here, so indicating what crypto businesses will have a reporting obligation. Now, CARF applies only to reporting crypto asset service providers, or RCASPs, as we decided we would call them. RCASPs are any individual or entity that, as a business, provides a service effectuating exchange transactions for or on behalf of customers, including by acting as a counterparty or as an intermediary to such exchange transactions, or by making available a trading platform. Now, what are we looking at when we're looking at exchange transactions? So that's an exchange between relevant crypto assets and fiat currencies, an exchange between one or more forms of relevant crypto assets.
So just to pause there a minute, Rebecca, I think one of the potential issues that I foresee is going to be determining whether or not these entities are carrying on, or individuals are carrying on, the requisite activities as a business, because I mean that's always a tricky question, and whether or not something's, I mean, it's not quite the same, but it's a bit like the question of whether or not something is in the nature of trade, which obviously has produced reams of case law in England and Wales, and indeed the UK more generally. But of course, we have the additional problem here that there's a risk that a variety of different jurisdictions are going to interpret what is being carried on as a business differently to each other. But on a practical note, because we're trying to stay practical here, the risk for me is that you're going to have difficulty with clients who say, yeah, but we're not a business, when actually they are. So that's something to get ready for, and it's definitely worth digging into the commentary there. So Rebecca, perhaps you could give us some more of the relevant definitions on the next slide.
Yes. So moving then, to the next slide. So other relevant definitions that are going to, of course, apply here. So crypto assets means the digital representation of value that relies on a cryptographically secured distributed ledger or similar technology to validate and secure transactions. A relevant crypto asset means a crypto asset that is not a closed loop crypto asset or a central bank digital currency.
So just to pause there, what we don't have is a definition of a closed loop crypto asset. I suspect that is quite deliberate. And of course, this is one of those difficulties. I don't know what a closed loop crypto asset is. I know enough about crypto assets to advise on the taxation of them. I can make a guess at what that means, but I don't think the OECD hasn't defined it. And that's unfortunate, because we've got a question which we'll come back to in a minute. But yeah, so it's not the most helpful definition. Sorry, Rebecca, do you want to continue?
Yes, no, that's fine. Also someone has raised their hand. I'm not sure how to assist with that. Maybe you could put it as a question, and then we can come back to it in a second. So fiat currency means the official currency of a jurisdiction issued by a jurisdiction or by a jurisdiction's designated central bank or monetary authority, as represented by physical banknotes. And then a reportable retail payment transaction is a transfer of relevant crypto assets in consideration of goods or services for a value exceeding USD 50,000.
So that last one's important because it that's sort of going to be one of the trigger provisions. It's a definition, but really it's a trigger provision for what is and isn't reportable in terms of transactions, but we'll come back to that. And now we've had a question from anonymous attendee who asked, are there any notable jurisdictions which aren't participating in this? How would this affect one's interactions with service providers in those jurisdictions? And we've also had anonymous attendee say, sorry, raised my hand by accident. That's fine. Don't worry about it. So notable jurisdictions not participating. No, it's the usual suspects. It's the usual suspects. And in terms of how this is going to affect your interactions with service providers in those jurisdictions, you're going to deal with it in exactly the same way that you would deal with it with regards to CRS non-participating jurisdictions. So there's quite a lot on that in the CRS commentary. And so if that's a live concern for you, or is likely to be a live concern for you at the moment, that's where I would start. Done that. Now we have somebody saying, I'm struggling with the concept of central bank digital currency. Isn't this normal money given the way banks work in the modern world? Okay, so I think if we well, bear with me a second. I'm going to come back to that question about central bank digital currency. We're going to define now on the next slide a specified electronic money product, and this may help with that query. So a CEMP is a digital representation of a single fiat currency issued on receipt of funds for the purpose of making payment transactions, represented by a claim on the issuer, denominated in the same fiat currency, accepted in payment by a natural or legal person other than the issuer, and by virtue of regulatory requirements to which the issuer is subject, redeemable at any time and at par value for the same fiat currency upon request of the holder of the product. So that's what a CEMP is, and this is interesting because CEMPs, as we've already said, they're going to be incorporated into CRS, and so with that, that is taking a big chunk of the central bank digital currency into CRS. Now, in terms of central bank digital currency, the question is, isn't this normal money given the way banking works in the modern world? No, it's not, and this is outside. This is sort of a technology question rather than a legal question, and so this is not advice. This is absolutely not advice. But I think the difference between money moving digitally and a central bank digital currency is that the central bank digital currency is a sort of designated central bank digital currency, may well come within that definition of CEMP that we have there. So I hope that's answered that question, but we can certainly come back to it at the end if it hasn't. Okay, so moving on, let's have a quick look onto the next slide at sort of, this is at the moment, my basic process as to how I would look to determine if a client is in scope. And there we have straight away at the top, is the service provider a business? This is an essential question, and it's not the easiest question to answer. It's a matter of fact. And you cannot accept at face value that it's not a business. You need to have enough facts to determine this, and it is in your client's interests that you do that. So whether or not someone carrying on what they're doing is a business is going to be something that you're going to have to come up with a process to deal with. Now, obviously, if you've got a big crypto exchange, there's absolutely no question. Where I think this is going to be most in sort of where there's going to be grey areas about this, is probably going to be individuals who trade in crypto, which is already an issue just under standard UK domestic law. But I think, yes, we do need to be asking this question, and a little bit, we need to know how a business is being defined to do that. Again, that's going to be a matter of looking at at some of the guidance that we get, but please do remember, guidance is not law. Even guidance from the OECD, even the commentaries on model conventions, etc., they're not law. And English case law really does warn against treating them as anything other than persuasive authority where they're relevant to the question in hand. But they're not law, and that is a difficult. So we've had an answer from an anonymous attendee on digital currency. Thank you very much. CBDCs, it's programmable money, and they've given the example, governments can theoretically impose restrictions on how it is spent. Digital money in bank accounts is not programmable in the same way. Thank you very much. That's a much more concise and accurate answer than I've given. We're very grateful for that. Thank you. So coming back to the process of what you're going to do here, is it a business? Is the service carrying out exchanges between crypto assets and fiat, or between different types of crypto assets? Are they an intermediary, counterparty, or trading platform? And again, it's these two questions that even if you have an individual carrying out a business, might well knock them out of being a CASP or an RCASP. So determining whether they're an intermediary, counterparty, or trading platform. Yes, there are going to be very obvious ones, but you need the facts. And you are going to have to dig for facts. And I would always say, this sounds really sort of don't trust your clients, but I'd say be skeptical where being within these categories is denied. And there are a couple of reasons for that. One is because of the general sort of initial denial that crypto was taxable. I think there's still some dragging of feet about whether or not rules apply at all, and of course they do. But secondly, your client isn't the person who knows how to apply law. You are. So really, they can give you all the facts, but you then need to say, well, that fact pattern is an intermediary, or no, it's not a counterparty, but it is a trading platform, or whatever it is. And so I say here, the point that I think has been made beautifully for me, which is, while your client may well have crypto and digital asset experience far beyond your own, they do not necessarily have the tax, financial, or accounting experience to be able to answer these questions themselves. So it's going to be a combined effort between you and the client to get there. But if you answer yes to those questions, then you've got a CASP and an RCASP, and therefore a reporting obligation. So let's move now to the next slide. Rebecca, can you tell us about what an RCASP, a reporting CASP, will have to do?
Yes. So the first thing it's going to have to do is undertake due diligence on all of its customers. And then the second thing, obviously, it's going to have to report on its reportable customers. Now, these are onerous tasks, and they must not be taken lightly. And RCASPs should begin work on designing systems that are going to be able to deal with this as soon as possible. Training and information gathering is vital at this stage. Now, just a sort of warning, do not make the mistake that everyone did for CRS, hoping that it won't apply or that it will go away. And really, sort of the key to this is raising awareness with potential clients and identifying them now, so that you can start investigations and begin the process of putting in place policies and procedures for when CARF comes into effect.
And actually, in terms of getting clients sort of CARF ready, it's definitely worth visiting with clients that you have who you think might be in scope for CARF, whether or not they should really already be in scope for CRS if they are not making CRS reports. Because as I've alluded to, and as we're going to discuss in more detail a bit later, I was very skeptical that CARF was actually necessary, because I think a few tweaks to CRS would have avoided a whole separate regime. That people disagree with me. I know Graham Jackson from Hassan's, who I speak with a great deal, disagrees with me, but I'm skeptical that CARF was really needed. So when you are looking at your clients and saying potentially you're within CARF, let's go and talk about it, are you an RCASP? It's also worth looking at whether or not they are actually a reporting FI under CRS. So this is a really useful sort of due diligence exercise to carry out. So we would recommend do it now, don't do it sort of 2 years down the line.
Yes. So moving then to individual due diligence, what do we have to do there? Well, firstly, obtain a self-certification form. So this is a standard form, and in earlier forms of CRS was done manually, and it must be obtained at the establishment of a relationship. You've got to confirm the reasonableness of the claims in the SCF. So you will have confirmed the reasonableness of the SCF if you have compared against your AML, KYC info, and you do not know or have reason to know that the self-certification is incorrect or unreliable.
So to pause there for a minute again and draw the parallel with CRS, sorry to jump in, Rebecca.
No, it's fine.
If you recall, what this means is essentially if somebody says to you, yeah, no, I'm only resident in Panama, please keep sending all of my correspondence to this address in the UK, which, that is my house, I do own it, no, it's not rented out. Is it reasonable to accept that they're only resident in Panama? It's that sort of question that you need to be asking yourself. And again, it's useful if now you're getting processes and procedures designed so that you can deal with that. So sorry, Rebecca, go on.
No, fine. And then so sort of moving from what Harriet's just said, if it fails, then the reasonableness must if it fails the reasonableness, you must gather CF or a reasonable explanation before providing the services. So if, as Harriet says, they come out with something that isn't a reasonable explanation, then you've got to establish what is a reasonable explanation before you go ahead.
Absolutely. And we've got a similar process on the next slide for entities. So on establishment of the relationship or within 12 months of the rule coming in, that's for pre-existing accounts, and it's the same for individuals. If you've got a pre-existing account, you need to get the information within 12 months of the rules coming into effect. Of course, if you do it sooner rather than later, you're not scrabbling around at the last minute. I say all this because I was around when both FATCA and CRS came in, and I can remember going into a large trust company which will remain nameless in a jurisdiction which will remain nameless, and spending 2 absolutely fun-packed, work-filled weeks right before Christmas getting everybody sorted out for FATCA, and then the subsequent year the self-same company going, oh, we've done the same for CRS, please can you come and help us again, and then having another 2 fun-filled weeks before. So really it helps to do it sooner rather than later. So again, for an entity, you obtain a self-certification form and you confirm its reasonableness. There are a few additional steps. You determine if the entity is either an excluded person or an active entity. And again, you're going to see similarities with oh, we seem to be going backwards through the slides. Could we go back to the main slide, please? Perfect, thank you. So you're going to see similarities here with what happens in CRS. So an excluded person, quoted and traded entity, entity related to a quoted and traded entity, government entity, international organization, FIs that are not managed by investment entities. And so an FI that is managed by investment entity is an investment entity, which is an investment entity by reason of the fact that it is managed by reporting FIs. So that's that is in the model rules for CARF, but that comes straight out of CRS really. If it's an excluded person, it's going to be, you don't need the same things. You also need to determine whether or not it is an active entity. If it's not an active entity or an excluded entity, then you need to get the controlling persons and get an SCF, a self-certification form from each of those controlling persons. Now, active or excluded entities are excluded from the need to know who the controlling persons are because they're low risk for fraud or avoidance. So going to the next slide, what's an active entity? Again, you're going to see a great deal of similarity with an active FI and CRS. It is a complicated and lengthy definition. It's set out in full on the slides. The points to focus on are emboldened here, that less than 50% of the entity's gross income for the preceding calendar year or other appropriate reporting period is passive income, and less than 50% of the assets held by the entity during the preceding calendar year or other appropriate reporting period are assets that produce or hold or are held for the production of passive income. And I've just put there CFCRS because that's pretty much identical. And then on the next page, the other important point about CRS, sorry, about an active entity for CARF is that the entity meets all of the following requirements on the next slide. And the first one is essentially that it excludes charitable organizer, is that it's a charitable organization. It's exempt from income tax, it has no shareholders, etc. So active entities are going to be a relatively limited set of entities, but you may see them more actually under CARF than you would in CRS. So bear in mind that you're going to need to check that. And again, this is something where I think waiting for that final commentary from the OECD is going to be useful. But as I've said, basically, an active entity is the same as it would be for CRS. Excluded person. Rebecca, talk to us about the excluded person definition.
Okay, so an excluded person is an entity, the stock of which is regularly traded on one or more established securities markets. It's an entity that is a related entity of the above. It's a government entity or an international organization, a central bank, or a financial institution other than the following investment entities. This is quite important. The gross income of which is primarily attributable to investing, reinvesting, or trading in financial assets or relevant crypto assets if the entity is managed by another entity that is a depository institution, a custodial institution, a specified insurance company, or a managed by IE. And just to note, sort of paralleling this with the CRS definition, it probably rarely applies. Would you agree, Harriet?
Yes, I mean, the one that you're going to come across is that one in the last bullet point, but in private practice, we're unlikely to see government entities, international organizations, or central banks, sadly. You might,
Alas.
yeah, alas, you might see something, you might see an excluded person because they're a listed company effectively, but yeah, they're not going to come up that much. So
then moving to the next slide. Entity due diligence continued. So once you have identified the controlling persons, you need to assess whether they are reportable, and that is a person who is resident in a reportable jurisdiction. What is a reportable jurisdiction? Well, a reportable jurisdiction is a jurisdiction with which there is an agreement to exchange information under CRS, and where it is a listed jurisdiction. And each country really helpfully has a different list. For example, there's no exchange relationship between Gibraltar and BVI, but there is between Jersey and BVI. So it's important to check.
It is, and we're going to. I think we're now going to have a separate list for CARF. But if you've dealt with CRS, you'll be aware that there's that massive bank of. You can go on the OECD website and you can look at who's got relationships with who. They can be quite random, and my anticipation is that for reasons that will defy comprehension, they won't be the same for CRS and CARF, because I think because we have the separate MCAA, we're going to have to activate those CARF relationships again, even though essentially it's the same thing in a lot of ways. So let's talk a little bit on the next slide about making the report. So who are we reporting for? Reportable persons. So individuals, active entities, controlling persons of non-active entities, resident in a reportable jurisdiction. It's going to be the same details that we do for CRS. So your TIN, your date of birth, and your place of residence. In terms of the financial information, we've got to give the name of the relevant crypto asset. We've got to list acquisitions and disposals of RCAs against fiat currency, acquisitions and disposals of RCA against other RCA. And remember, there is going to be this de minimis exemption. Report retail payment transactions, that's where the de minimis comes in. And other transfers of RCA to and by the reportable user. So there's some other transactions which are set out in the paragraphs mentioned there. And the wallet addresses to which the reporting crypto asset service provider has effectuated a transfer where they're not associated with the RCASP, or with an individual or entity that the RCASP provider knows or has reason to know is also a reporting CASP, but only to the extent the relevant reportable jurisdiction is included on a published list. So that's the list of that's the list that each country is going to produce, which shows who they have an exchange relationship with. So this is where CARF does differ a bit from CRS. We've got a broader range of information that needs to be reported, and I think this need to report wallet addresses is really interesting because, of course, one of the issues that we've been finding from a legal perspective with crypto assets, and it's not something that I deal with regularly, but I follow it because it's relevant to sort of how we deal with crypto assets in tax, or relevant points come up, is knowing who has got crypto assets. So you're getting a lot of cases of so-and-so, so-and-so, and so-and-so versus unknown persons, because they know crypto assets have gone from their wallet. They might even know where they've gone to, but they don't know who to get hold of to get those crypto assets back. So that is an interesting point, that revenue authorities are getting information about wallets. And as technology develops, I think that information is going to become increasingly important. So turning now to a bit more detail on the interaction with CRS. I've said, was the CARF really necessary? And these are the new bits to CARF that were sort of developed in the July report. And they say that an RCASP that is also a reporting FI for CRS can rely on its due diligence procedures completed previously. Again, an RCASP can rely on a self-certification already collected for other tax purposes, provided it meets the requirements of CARF. And an RCASP can rely on a third party to fulfill its due diligence obligations, though they're still its obligations. So was the CARF necessary at all? Many RCASPs are CRS reporting FIs. Many more, I suspect, should be reporting FIs. And my feeling is that this would have been better done within CRS, particularly because we're now seeing that CRS is being amended in any event to deal with digital assets itself. So I'm not sure what the thinking was in having the two separate regimes, but we are where we are. And moving on, just how does this interact with MDR, which is the mandatory disclosure rules? And I always call MDR an anti-avoidance provision, because effectively MDR is anti-CRS avoidance rules. And so you're going to need to consider them in the context of CARF as well. You're going to need to have within the process or policy within the organization, you're going to know that there is a procedure in place where somebody says, we don't have to make a CARF report, or the RCAS doesn't have to make a CARF report. Is that going to trigger an MDR report instead? If you're not clued up on MDR, I did a seminar on it about 3 years ago, which is on YouTube. It is an old one, so just be aware that it may not be fully up to date, but it's still got lots of relevant information about MDR and about DAC 6. So do have a look at that in preparation for the interaction of MDR and CRS. And so what do you need to do now? Rebecca, talk us through some of the practical things on the next slide that we can do right now to get prepared, or to get our clients prepared if it's not us.
Yes. Okay. So some of the practical things that you can be doing right now, and indeed should be doing right now. So training. You need to analyze the situation internally. Resourcing. So every fiduciary should have a dedicated CRS or FATCA person, and now they need to be CARF ready too. Those extremely lucky people. You need to educate your executives, and this is not simple, and it should not be something that they just dump on compliance, tempting as that might be. And you need to get help where things are confusing or you're not sure what to do. Getting help is always the best answer.
Yes, and what I would say about all of this is it's worth now, even though there might be some more tweaks to the rules, it's worth getting everything in place over the next couple of years so that you are ready. But what I would say the most important thing to do now is to be getting your clients to analyze their situation internally and say, look, if we're caught by CRS, are we also caught by CARF? If we think we're not caught by CRS, are we actually caught by CRS and we're going to be caught by CARF? Let's analyze this. Are we caught by CRS? No, but yes, we will be in scope for CARF. We need to have an eye on that. We need to be ready. We need to know that we have the resources. We need to be digging out that information sooner rather than later. So we now have a firm timetable because we've got a joint commitment of 48 countries of when this is going to come into effect. In an ideal world, we really want to be encouraging clients to act now and not in 2 years and 10 months time, right before they need to start doing everything. So I'm sorry. So that is what you need to be doing now. And it's not urgent in the sense that you're not going to be in trouble if you don't do it straight away. However, particularly for institutions that haven't been run like traditional financial institutions are, this may be a real sea change for them, getting prepared to do this sort of due diligence. So it is worth definitely starting with awareness and definitely getting your clients to consider if they need to look at this. We are here to help, and on the next slide, there are details. If you want any further information or you think we need to help, you need some help, don't hesitate to contact us. And of course, the first point at which you can contact us is if anyone's got any questions now, we'd be delighted to answer them. But if you don't want to ask in the general seminar, just drop either or both of us an email. And thank you for listening. So we'll wait a couple of minutes to see if we get any questions. Or comments. You can comment. Tell me what else I don't know about digital technology, because I am always learning, but it's a tough field to sort of break into, particularly if you're doing a full-time tax job as well. So we don't seem to have any questions yet. Does anyone have? Oh, we've got a question.
There's something.
Yes, the slides will be available. Yes, I think they're going to be emailed out to attendees. So if you signed up, I think you'll be able to get a copy of the slides. Any problems, they don't arrive, you've got our email addresses and we can make sure that they get sent.
Oh, and also I think a recording of this is going, it's on our website, isn't it, Harriet?
It's going to be on, there's going to be a link to it on our website. We have a YouTube channel which has all of our seminars. We run a little online series called Tax Snacks. That's going to be on there as well. So please do have a look at that. If you want to watch this again, or if you think it would be useful for your clients, then yeah, do recommend that they go and have a look at it on YouTube. So we do have a question. Given GDPR arguments about FATCA, could that be raised in this context? Look, all of the issues that can be raised in relation to FATCA and indeed CRS about GDPR, so privacy effectively, but also the human rights arguments are potentially also relevant here. That's absolutely right. However, that is a live issue, and it's one to keep an eye on. But I think the best thing that you can do is, one of the things that I see a lot is people file information or exchange information, sorry, or give information to be exchanged on the basis that better safe than sorry. But of course, it's not better safe than sorry, because if you've answered a question, if you've provided information that the Revenue Authority isn't entitled to, if you've breached GDPR, you're not safe and you may well be sorry. So really, I think the answer to that at the moment, until we have clear case law authority on those arguments around GDPR and indeed the human rights element, until we have that clear case law authority, what we need to do is look at making sure we are definitely, any information we provide is definitely squarely within the provisions, and that goes for FATCA, it goes for CRS, and it's going to go for CARF. But yes, I think you're absolutely right, anonymous attendee, that the position is basically the same across the three. So I hope that answers that question. Laura Hitch has raised her hand. Laura, I don't know, I for some reason we can't get admin privileges, so I don't know if you want to stick a question, if you have one, in the Q&A, because I I don't think I can. Oh, I can. Laura, you can talk now if you'd like to. No, I think Laura's fine. And maybe raised her hand in error. So if nobody else has any questions, thank you for your lovely comments. Thank you for attending. I'm delighted to see so many people come out for this when I'm sure you've all got really pressing things, particularly if you're in the UK and you've got anything to do with tax returns. But actually, I'm delighted to see how many people are taking this seriously. Thank you so much for attending, and hopefully see you all again soon. So thank you and goodbye.
Thank you. Bye.